Namaste to everyone. A very warm welcome to everyone on board for today's Sunday Law Bulletin. Thank you so much and a very warm welcome to everybody. Let us commence. I hope I'm audible and visible. Yes. Okay. So, before we start with today's program, I would like to briefly introduce Lawyers Development Forum for all the newcomers, followed by the introduction of our expert speaker, which will be delivered in a short while, which is already circulated in the groups. Yeah, let us begin. So, Lawyers Development Forum, that is LDF, has been established to foster development and promote interest in the legal field. Not only do we organize academic lecture series that have been immensely beneficial for many young advocates, but also we arrange sporting activities for advocates, including cricket matches and badminton tournaments for the entire advocate fraternity. We also conduct conferences featuring esteemed High Court judges and expert speakers from the legal profession who provide valuable guidance and insights. Moreover, we host this Sunday Law Bulletin, as you all know, every Sunday, where experts from various legal specializations share their knowledge and address key topics of importance. For this endeavor, we are extremely grateful to Advocate Dr. Rajendra Anbhule sir, Founder President LDF, Advocate Vijay Shelar sir, Secretary Lawyers Development Forum, Advocate Abhishek Jagtap sir, President Lawyers Development Forum Pune, for starting this. As we move ahead, let us briefly walk through the program. It would take hardly a minute. Today, we have a special session by a very special guest speaker. He is none other than Advocate Dr. Sudhakar Avhad, sir. He would be guiding us on the topic Overview of the Code of Civil Procedure 1908 and how to analyze the contents, which is extremely important for all the new entrants in the legal profession. Sir, we are deeply honored to have your presence with us today on this bright Sunday morning. Before we commence, let me give a brief introduction about our expert speaker. We have with us the gracious presence of an eminent speaker, an outstanding teacher, a brilliant academician, and a well-known advocate and erudite scholar, whose name needs no introduction. We are deeply honored to have the presence of Advocate Dr. Sudhakar Avhad, sir. Sir, a warm welcome from LDF here for delivering this session. Sir has been former chairman of BCMG. He has been teaching law since 1977 and he conducts coaching for JMFC exams. Under his able tutelage, thousands of advocates across India and judges have made their mark. He has been a practicing lawyer since 1977, specializing in civil, criminal, revenue, and land laws. Having graduated from modern college with bachelor's in science, he has completed his LLB from Pune University and has been awarded the Tulpule Gold Medal. His PhD is on global dimensions of human rights and evaluation of fundamental rights under the Indian Constitution. He is also the author of several notable books like Tuftsman, Law of Notices, Judicial Services Examination, and Real Estate Development and Regulation Act 2016. So we are excited to have your presence and to gain insights from you, sir. So we are awaiting your session, sir. So you may now kindly proceed. Thank you so much, sir.
Good morning to all. I'm really thankful to the organizers, Lawyers Development Forum, Dr. Anbhule sir, and Advocate Abhishek ji, and all organizers. Friends, today topic has been assigned to me is overview of the Code of Civil Procedure 1908. Today, I'm going to share with you, it is in the form of a dialogue rather, that I'm not going to teach you anything. The today's lecture or interaction between you and me is not in respect of any of the contents of the Civil Procedure Code, but to help the new entrants in the legal profession. This is how to read Civil Procedure Code. Friends, sometimes it is said the Code of Civil Procedure 1908 is said to be Jnaneshwari or Bhavartha Deepika of advocates and lawyers. This is especially so as every reading of Jnaneshwari or Bhavartha Deepika gives us further and further insight. Every time we understand different colors of the contents of Naneshwari. Likewise, friends, in the Code of Civil Procedure Code 1908, whenever you read it again and again, you come to know about the different colors and the spectrum of colors as to the meaning and interpretation of the provisions in the Code of Civil Procedure Code. And therefore, friends, this is essential part of civil practice. Any new entrant in the legal profession, he should know not only the contents, but how to read the contents. And my today's exercise is to welcome the new entrants in the legal profession and to make them aware how to read this book. The contents we'll speak on later on, but today for 1 hour or so, as the organizers permit me to do so, I will be sharing with you how to read this book. What are the different aspects, how you shall take into consideration while opening up this book. And we'll start from the very name itself, name of the subject itself. In the course of the discussion, we'll look into the nature of today's subject, analysis of today's subject, the delegation of power stated therein, how we shall prepare for a civil trial or a civil case, then various steps or stages in civil trial and incidental proceedings therein. Usually you'll find in the beginning, I will tell you how this interesting approach to the subject is. We come to know that under Order 20 of the Civil Procedure Code, judgment is finally pronounced and the proceedings are closed. Civil trial, civil proceedings, they come to an end. Usually, the new entrants, they know that this is the only stage whereby civil trial or civil proceeding comes to an end. But friends, there are around 14 ways whereby civil trial comes to an end. Order 20 or the judgment delivered under Order 20 is not the only way whereby civil trial comes to an end. There are around 14 stages or kinds whereby, methods whereby civil trial comes to an end and the civil suit stops and further stages are not to be entered into. Let us see today how this happens. Let us see today what is the arrangement of the orders from Order 1 to Order 20, especially in respect of the civil trial. And for this purpose, our friends will be analyzing the contents of this law, the nature of this law, and the provisions in this law. For this purpose, friends, we have to understand why this is called as a code. Civil lawyers, senior lawyers who have practiced for many years into this, for them it is not. But for the new entrant who joined last year or before that, for them I'll tell you why this is called as a code, not as civil procedure law. It is not civil procedure law, it is civil procedure code. And for this purpose, friends, new entrants, the new graduates, they shall keep in mind there are such terms used: Indian Contract Act, Civil Procedure Code, or Law of Torts. So sometimes any law is called as law only, not act or code. Sometimes such a law is called as an act, not as a code. And sometimes it is called as code and not act. In one sentence, at the bottom line of all this discussion, as a concluding remark of this discussion, I will tell you, when any law on the point is given by the statute or by law of the parliament, that is necessarily classified as act or code. So Indian Contract Act, Civil Procedure Code. But it is not the Torts Act, it is law of torts. When any law, it develops out of the precedent, theory of precedent, or it develops out of custom or traditions, then that becomes a law and not act. Therefore, the basic division of the legal topics is as to statutory laws and such laws which are not statutory, which are developed out of the custom or out of theory of precedent. Secondly, the statutory laws, they are again divided into two parts. Firstly, law which is called as act, like Indian Contract Act, and the law which is called as a code, like today's subject of Code of Civil Procedure. In short, one sentence division is when law is dealing a particular branch of law, Indian Contract Act, then it is called as an act. But if tomorrow Parliament decides why to have the lawyers different topics like Indian Contract Act, Sale of Goods Act, the Partnership Act, the LLP Act, and so on. They put all these laws together in one book. Then that will be called as Indian Contract Code and not Act. And therefore, when there is exhaustive treatment given to any subject, that is called as a code. And therefore, today's law is code. And therefore, for a civil practitioner, therefore, for a junior lawyer, if he intends to resume and to take the practice in civil courts and civil law, then he need not refer to any other procedural law except civil procedure code, and therefore it is called as code or exhaustive law on the point. That we have to keep in mind. And secondly, this is code. Secondly, procedure. Why this is called as procedure? Whether if you read in Indian Contract Act, the word procedure is appearing? No. However, in this law, there is a procedure. And therefore, we have to understand, in the beginning, laws are classified, friends, into three categories. New entrants should keep in mind, laws are called to be substantive laws, laws are said to be procedural laws, and thirdly, laws, they are called as adjective laws. Substantive laws are those laws wherein rights and duties are created. And those rights and duties are to be enforced in the courts, and for enforcing them into courts, procedural laws are required. So, rights and duties are created under the Indian Contract Act, the Specific Relief Act, and those rights and duties therein are enforced in the courts with the help of the Code of Civil Procedure. That is the distinction. And then some laws are called as adjective laws, like Indian Evidence Act. Indian Evidence Act, therefore, is said to be an adjective law, especially the Bharatiya Saksha Adhiniyam 2023. In its statement of objects and reasons, the Parliament has called and branded it as an adjective law. And friends, therefore, this is the beginning as to reading of the name of the book itself, Procedure and Code. And this procedure and code started in India, especially in the year 1859, during British period, when Britishers came in India and they started and decided to rule India. They wanted better administration in support. And so as to have better administration in supports, they had established courts at various places. And when they established courts at various places, then they provided for various laws. And during British period, the law was enacted, and that was especially the Code of Civil Procedure of 1859. In the year 1859, when this law was enacted, this law enacted with the objective. This was enacted with the objective as to consolidate and so as to define and amend law as to civil procedure. This has been done. And once this law has been enacted in the year 1859, and then that was further amended by the Parliament in the year 1908. During British period, the legislature substituted, rather, instead of amended, I will say substituted the old code by the new code of 1908. And that code, the code during British period, we have followed till today. For more than 100 years, we are following the code of 1908 with minor modifications. During my lifetime itself, I have seen twice. When I was a law student and I was in the last year, the law was amended in the year 1976. There were major amendments in Civil Procedure Code in the year 1976. And then this law, it had major amendments in the year 1999 and 202. Especially these various amendments, they have been incorporated in today's Civil Procedure Code of 1908. Friends, so as to understand this law, sometimes we the lawyers or the beginner may feel that to practice in civil law court, only the book on the Civil Procedure Code will be sufficient, or enacted law by the Parliament will be sufficient. Friends, it is not true. We have to understand the various perspective of the civil practice. We have to look into various aspects. First, the scope of the today's discussion is in respect of the provisions in sections 1 to 158. 1 to 158 is the first part as to sections. Then comes, there are schedules in this law. Previously, there were 5 schedules. Of the 5 schedules, Schedule 2, 3, 4, and 5, they have been deleted. And only Schedule 1 remains in the code of today's Code of Civil Procedure. In the CPC, Schedule 1 relates to various orders. All orders we speak in the courts, they are provided in orders 1 to or 51 of the Civil Procedure Code. So first, section 1 to 158, and then second, the first schedule comprising of orders 1 to 51. But this is not all. In addition to that, in this Civil Procedure Code, there are state amendments provided. Especially, these state amendments are provided by virtue of the chapter incorporated in the Civil Procedure Code in section 121 to section 131. And that chapter relates to delegation of power, whereby powers have been delegated by the Parliament, by the central legislature to the state legislature. So, state legislature within its scope as provided in section 121 to section 131 chapter may provide for the state amendments. State can have its own amendments. And lastly, by virtue of the provisions in section 125 read with section 128 that provides for the powers of the high courts to make its own rules subject to approval by the state legislature. Therefore, this is all. When the rules are made by virtue of the delegated powers by the high courts, respective high courts, then that becomes a civil manual. And therefore, today in Maharashtra, we have Civil Procedure Code comprising of section 1 to 158. We have got our schedule first as to order 1 to order 51. Thirdly, we have got state amendments in our state. And fourthly, we have civil manual of the Bombay High Court. This is all. And therefore, whenever you intend to take up your practice and to read the Civil Procedure Code, how to practice in Civil Procedure Code, bare act and CPC itself is not sufficient. You should also have in your library or with you the civil manual of the Bombay High Court. That makes a complete set of rules so that you are prepared to face any civil trial in the courts. Especially you will find in the Civil Procedure Code, there are appendices, appendix and appendices, plural. So there are appendices A to H. So first there are sections, then there is a schedule. In the schedule there are orders, and then there are various appendices. In the appendices there are appendix A to H. In these various appendices, you'll say that why it is material. Friends, you'll find if you read the bare act of the Civil Procedure Code itself, that is sufficient to have the overview of the Civil Procedure Code. Especially you'll find, if you read Appendix A, then you will find in Appendix A, there are various forms of pleadings provided. Around 49 forms of plaints are provided. Around 16 forms of written statement are provided in the pleading form of the CPC at the end. And therefore, you must read how specific performance suit is drafted, how various partition suits are drafted. Everything is provided in Civil Procedure Code. Bare minimum, the minimum things to be incorporated in your plaint are provided. Minimum things to be incorporated in your written statement, they are provided. You will ask me a question that whenever you visit the court along with your senior friends, then you will observe that court says that your plaint is faulty, and therefore that may be written under Order 7 Rule 10 or may be rejected under Order 7 Rule 11. This is because of the deficit pleadings. Or sometimes in your written statement, court will say there are evasive denials. There must be specific denials. It is not merely Order 6, Order 7, and Order 8 of the CPC, but along with that, you have to read the appendices and Appendix A as to pleadings. In addition to that, you have to understand various processes as provided in Appendix B. The contents is a different part, but you have to read the processes in Appendix B. Then comes Appendix C. At a later stage of the discussion, you will come to know as to discovery, then as to inspection and admissions. As to discovery, inspection, and admissions, Appendix C provides for. Then Appendix D Appendix D provides for decrees. Appendix E provides for execution of decrees. Appendix F provides for supplemental proceedings. Appendix G provides for appeals, reference, and review. Appendix H provides for miscellaneous provisions. This makes all. So, any new lawyer who joins this profession, before he takes up any drafting, before he takes up any instructions from the clients, you should know how actually the provisions they come into the play. You must know the interplay between these four aspects: sections, decrees, appendices, and civil manual. The interplay between, the interrelationship between these four components of the civil practice, you should know by heart. Then only you can go for the further things. Say as to pleadings, you'll ask me a question. So why it is material that you should know the pleadings in Appendix A? For a reason. Title of the suit, it starts from the very beginning. As soon as you take pen in your hand, or say nowadays in your tab or in your laptop or computer, if you want to type title of the suit, how to write it, how to describe the parties, it is likely that you may commit mistake. And there may be at a later stage striking of the pleadings for these defective pleadings. And for this reason, you are guided by the minimum things as provided in Appendix A as to pleadings. This you should know. How parties are to be described, how the plaint and title is to be given, everything is provided in all details, especially in respect of Appendix A to H. This provides and gives you insight as to application of the contents of the Civil Procedure Code practically. Say, for instance, there is a provision given as to specific performance suit. Those seniors, if any is present in the today's session, will know that we always say what is should to be pleaded, that the plaintiff was ready and willing to perform his part under the contract. Where from it comes? This comes from the provisions provided in the specific relief act. There is a provision made, but as to pleadings, that is provided in the format provided in the Civil Procedure Code. So this should be read together. You should cultivate habit to read these provisions together. Such habit should be inculcated to you, imbibe you in the beginning itself. When your age in the practice is 1 or 2 years, herefrom you should know how to read the book. Contents can be read at any time, but how to read it is the today's perspective. This you should know. So in addition to this, say for instance, you want to go ahead and client comes to you. If a client comes to you and he says, sir, I want to file a suit. And then you want to take instructions from the client. How to proceed? We'll come to two aspects. How to proceed in the civil practice. What are the important aspects of the civil practice? What are the important steps of the civil practice? And for this purpose, friends, I will tell you, the first is taking instructions from the client. Before you start drafting, you have to take instructions from the client, because friends, this is very material. It is like a foundation of a structure. If you want to have the structure, say 5-10 story building, then your foundation should be perfect. And this foundation is with reference to instruction taken from the clients. Say for instance, client has not disclosed all the instructions to you, all the information to you, nor you have failed in extracting from him the instructions. Especially this happens in rural areas. In my about 48 years practice, I have seen very intelligent clients also sometimes, either they intentionally keep some information away from you, or they inadvertently don't disclose the information to you. So it is your skill. When client comes in your contract, simply whatever he says, you shall not incorporate. You're officer of the court. You're not only mouthpiece of your client. You have to do justice to the client. And so as to do justice to the client, his entire story must be understood by you from your bottom of heart. And to understand it, you must get all instructions, all relevant instructions from the client. How to take it? This is a skill also. At this age also, sometimes I feel that I must develop myself further, because sometimes simply not giving time to the client and taking papers from him and then starting your own drafting is not sufficient. You must have a good hearing given to the client for the purpose of taking the instructions. What has happened? What are the relevant papers? Everything should be heard and then shall be noted by you, and so that from that you will get insight. Any more instruction, any more information is required or not. If this is so, once there is a first interview with your client based on the instructions for the civil practice, then second stage comes. What is second stage? Second stage in this behalf would be the client's case is based on some documents and papers. You know, in Bharatiya Saksha Adhiniyam, Old Indian Evidence Act of 1872, that there are oral and documentary evidence proceedings. So if the case is based on documentary evidence, you should collect from him what are the available documents with him. Again, you read the provisions in earlier sections of civil procedure, the Indian Evidence Act, section 61 to section 65, primary and secondary evidence. What are the documents available? Whether originals are there, primary evidence is available or not. If not, then certified copies to be obtained, and then so as to make certified copy to be produced in record, you must comply with the provisions in those important 5 sections of the old law and new sections in the Bharatiya Saksha Adhiniyam 2023. So first you get information and instructions and then get all the documents. Once this is done, then you have to start drafting. And so as to start drafting, so as to undertake drafting, first you should know parties to the suit. Order 1 of the Civil Procedure Code relates to parties to the suit. You must know that who are the parties. Not here only the client, but depending on the nature of the suit, depending on nature of the proceeding, you have to decide who are to be joined as party to the proceeding. Otherwise, you know, or when you read order 1, there are various consequences. If necessary party is not joined, there is a consequence. If a party is unnecessarily joined, another consequence. Or therefore, for this purpose, you have to understand who shall be parties to the proceeding, non-joiner of the necessary party and misjoiner of the necessary party. This we should read from order 1 of the Civil Procedure Code. And therefore, in this connection, once you get the instruction, then you get the parties to the proceeding. For framing of the suit, you must know who are the parties, necessary parties to the suit. Then comes the third aspect, description of property. If at all it is a suit relating to description of property, then you should know the description of the property or the claim to be made in the suit. Especially you will find all this we are discussing regarding plaint and not the suit. For juniors, new entrants, I will make it clear what is the difference between plaint and a suit. In order 6, order 7, we read about plaint. In order 8, we read about return statement. But in further stages, we say suit. Plaint is not dismissed, suit is dismissed. Plaint is presented and suit is dismissed. What is the difference between a plaint and a suit? And friends, a very basic distinction. Plaint is a paper. Today, it may be e-submissions, but nevertheless, it is a paper. It is scanned and you now submit in the registry. But when this plaint, this is a paper, when it is registered in the court, then that becomes a suit. So, plaint when registered will become a suit. Plaint is not registered, suit is registered. And therefore, when such a suit is to be registered, then the issue comes as to description of property. Description of property, you should write perfectly. Otherwise, on this, because of this, there can be further consequences at the time of execution of a decree. What will happen, I will tell, because of your inadvertence, because of your ignorance, or because of your negligence, You have not described the property specifically. Say, for instance, entire trial has undergone, evidence is recorded, arguments are over, and judgment is pronounced. And when thereafter you come in the court under Order 21 of the Civil Procedure Code for execution of the decree. And when you go to the court for the execution of a decree, and then executing court finds that decree is not executable because of the description of the property, or rather it may be wrong description, or there may be imperfect description, and then decree may not be exercised, decree may not be executed. And therefore, for this purpose, at the very inception, at the very base, you have to take proper precaution for proper framing of the suit, for proper framing of the plaint, and for proper preparation of the plaint. There should be not only title to be perfect, not only the parties to be properly stated, but there shall be also the description of the property or the cost to be stated. Especially, cause of action is a very material issue, friends. You have to state cause of action properly. That it is not that it is your wishful thinking. It is not your client's wishful thinking because he has got money and because he has got sufficient time, and then he comes to a lawyer and says, sir, let us go to the court. It is not his wishful thinking. This case, your client's case, must be within the framework of the Civil Procedure Code. And the framework of the Civil Procedure Code provides that for this purpose, there must be a cause of action. Order 2 provides for the cause of action and how you can institute a suit in the court based on this. Order 1 and Order 2 are very interesting, friends, as I have decided not to enter into the contents thereof, but Order 1 and Order 2 Rule 1 and Order 2 Rule 2 are very material, because there shall be the joinder of the causes of action, and all causes of action should be taken together. If not, then Order 2 Rule 2 is hitting the point. And then the points, the causes of action which were available to you at the time of drafting of the plaint and institution of a suit were not taken into the plaint, then friends, at a later stage, by virtue of Order 2 Rule 2, that may not be taken unless in the beginning you pray to the court, you request the court for deferring that issue to be taken at a later stage. Therefore, in the beginning only, you have to take all these precautions. Friends, in the practice, there are two things. Lawyer is not writing the judgment. That is the judge's job. We have to deliver the goods. And while delivering the goods, you must have mastery over the facts. Not only mastery over the facts, but mastery over the law. But before you have mastery over the law, you should have mastery over the facts. This is within your hand. Any junior lawyer, he can study the facts better than a senior lawyer. And therefore, when a client comes to you, there is an opportunity for you to look into the papers. Then you should prepare thoroughly, and you should have mastery over the facts. This will help you two ways, friends. Your seniors, they don't have sufficient time. I know they're overburdened, and they may not indulge into all these various facts and various papers. Good junior, he will study all the facts. He will have his own notes on this and will share it with the seniors. Senior will find, yes, this junior is very helpful. He knows how to prepare a civil trial. He knows how to prepare the plaint. Then once this is done, this is studied, you have to keep in mind whether in this suit, in this proceeding, or filing of the plaint, whether notice is necessary. You take the instruction, you study collect the papers, and after collecting it, you have to understand whether any notice is necessary or not, and what is the present law on the point. For my junior colleagues, I will tell, notices are of two kinds. These two kinds of notices are, some notices are statutory notices and some are not statutory notices. Those statutory notices are those which is a condition precedent for institution of a suit and presentation of plaints. If that is not done, then your suit will be, or your plaint will be hit. And therefore, say for instance, the provisions in respect of order section 79 and section 80 of CPC. Section 79 and section 80 of CPC, if you intend to file any suit against the government, then notice is necessary as provided in those two sections. Likewise, if you want to file a suit against Pune Municipal Corporation, if you want to file a suit against a cooperative society, section 164 comes into operation. So, under various special laws, these are special laws. Under various special laws, there are provisions as to notices to be served on such various institutions and dignitaries. Then, such notices should be given. Otherwise, friends, your ignorance will cost dearly to your client. You have done everything perfectly, but notice was not given for that flimsy ground, for that small ground, but a great lapse on your point, your client will lose. And therefore, see that all the formalities regarding notices are complied with. Once this plaint is filed, once this plaint is presented by you, then comes the next consequence. Everything is done, notice is given, plaint is prepared thoroughly. Then you have to decide the jurisdiction in the plaint. Because in this connection, the consequence is stated, especially with reference to Order 7, Rule 10. Say, for instance, you are presenting a plaint in the wrong court. Then what happens? Especially you'll find the provisions in respect of section 16 to section 21 of the Civil Procedure Code, the deal as to jurisdiction in respect of institution of suits regarding immovable property, regarding torts and other things. Especially section 16, 17 and section 18 of the Civil Procedure Code relates to the suits in respect of immovable property. Suit to be instituted where property is situated. And therefore, you'll find in respect of this, you have to read the relevant provisions. Suit to be instituted as per section 15, competent court of the lowest grade. Say in Pune court, there are several senior division courts and several junior divisions court. Your client says, no, sir, let us file our suit in senior division only. You should know section 15, not only section 16, 17 and 18, but say that Pune court is competent, but competent court of the lowest grade, suit to be instituted in civil judge junior division as per the valuation or as per the provisions of law in the court of senior division. Why? Why senior division or junior division? Why the valuation? Competent court of the lowest grade is the consequence in respect of section 15 and then further read with section 16 to section 21 of this court. This is the consequence in respect of jurisdiction to be seen. Then proper valuation to be done. If you go to the court, proper valuation is to be done. Because on valuation, there is Suits Valuation Act and proper stamp duty is to be paid on that. Otherwise, what will happen? If the suit is not properly valued or it is insufficiently stamped, immediately Order 7, Rule 11 will come into operation. And you will find there are 6 grounds we will be discussing later on as per Order 7, Rule 11. Then, as per Order 7, Rule 11, what will happen? One of the grounds is as to suit is not properly valued and it is insufficiently stamped. If you do not obey the orders thereafter passed by the court, then your plaint is liable to be rejected. You will be out of the court. And therefore, these provisions are material at the inception itself, in the beginning itself. Once this is done, when all stages you take into consideration, then your plaint will be presented. Your plaint is presented in the court, then that will be registered in the suit register, it will be numbered, and then the further stages to follow. What is the next step, important step to follow? And you should know, simply giving it to the registry, and now online giving it to the registry is not sufficient. The further stage is stated in Order 5 of Civil Procedure Code. Order 5 provides for service of a summons. In our days, it was any time. We could take, people could take, our clients could take sometimes 2 years for service of summons. Now, amended law, especially Order 5 read with Order 9, provides for 30 days period and sometimes extended maximum to 90 days period. So summons to be served within this stipulated period of 30 or say extended 90 days period. If not, then the consequences are to be seen. And let us see what happens as per Order 5 read with Order 9 of the Civil Procedure. So summons is to be provided. Summons is has to be served as per Order 5. If not, what is the consequence? Order 9 comes into operation. That is how you must know how to read various orders together. If order 5 is not properly understood, then you will not understand order 9. So order 5 provides for service of summons and plaintiff's responsibility or plaintiff's role in such a service of summons you must know before you go to the court. And once you institute a suit, suits are instituted, applications are made, and appeals are preferred. By way of reference to the junior lawyers, I will say, we in the court say suits are made, suits are filed, appeals are filed, applications are filed, but there is a phraseology. Junior lawyer shall inculcate in him, whenever it is application is made. Whenever it is suit, it is instituted. And whereas it is appeal, it is preferred. Appeal is preferred. So this is a peculiar phraseology you must keep in mind. It does not matter if you say file, but whenever you utter such word, then judge knows, or other person hearing you behind you, the other lawyer, they come to know, yes, this junior lawyer knows the distinction between instituted, preferred, and filed and made. This is the consequence in respect of order 5 as to summons to be served. And consequences thereof are to be found in order 9 of the Civil Procedure Code. If on the appointed date, summons is duly served or not, that is to be seen. If you fail to deposit the requisite fees for service of summons, then friends, court is entirely at the cost of your client. As we put our hand in the pocket of the client for fees, likewise, state administration is putting its hand in the pocket of the client for cost of everything. This plaint, which was submitted in the court, its summons will be served to the defendant or defendants, if there are more, at the cost of your client. This cost you have to deposit for due and effective service of summons. First, we come to cost. If this cost is not deposited, and because of non-depositing of it, summons is not sent and summons is not served, then the consequence is stated in order 9, rule 2. Your suit is liable to be dismissed only for a technical reason of non-depositing of the cost for service of the summons. Those for that stamp duty or other consequences as to the service of the summons. Your suit is liable to be dismissed on this simple ground itself. Therefore, we have to keep in mind the consequences stated in order 5. You read it, order 9, rule 2 thereof. Then comes the third consequence. As per order 9, especially as stated in rule 3, on the appointed date, stated in the summons, parties should be present before the court. And if neither party appears before the court on the appointed date, then suit is liable to be dismissed under rule 3 of order 9 of civil procedure. And then comes the next consequence. That next consequence is as to order 9, rule 5. It is not merely depositing the cost of the summons in the beginning only, but it comes at the later stage also. It comes at the later stage also because you pay the cost, and therefore there is no consequence as stated as per order 9, rule 2. And therefore court says, okay, proceed. Summons is sent, but summons comes back. There are various tricks people know in the courts. Your clerk is more clever than you in the court. Clerk means your private clerk, person helping you. He knows how summons comes back. Sometimes it is locked. Sometimes it is not found. There are various processes. And then it comes back and address is incomplete. The addressee has left the premises. Then again there has to be reissuance of the summons. It is your duty. Till then, till summons is served on the defendant, it is the plaintiff's duty to ensure that there is a due and effective service of summons. Simply giving the papers to the court and simply paying the cost is not sufficient. If summons is sent and it comes unserved back, then there has to be reissuance of the summons. If it is not reissued properly, order 9, rule 5 will result into dismissal of your suit. So order 5 provides that if you fail to do it within 7 days time, and if you fail also to provide as many copies as are the defendants, then your suit is liable to be dismissed. The law is made more strict by amendment. When the summons is sent and it comes back within 7 days time, you have to take the further steps. Otherwise, consequence under Order 9, Rule 5 will follow. Then comes the next consequence. Once this is done, summons is served, summons is sent, and then once everything has been done, the defendant remains absent. You must be careful. There can be ex parte order or ex parte decree. You being a junior lawyer, you being a new entrant, you shall help your senior, remain present in the court. Remain present in the court. Maybe it is not a need, there is no need for hearing. There is no need for defendant to appear personally. But on the appointed date, if there is no adjournment application which is duly granted by the court, or secondly, there is absence of the defendant, and hence you should press for that there shall be ex parte order to be passed. Ex parte order will be passed against the defendant, and then also he remains absent, then there can be ex parte decree to be passed. If this is done, then proceeding will come to an end. Therefore, it depends on you how vigilant you are, how conversant you are with these various nuances. These small things, but effective things in the Civil Procedure Code. This you have to follow, and you have to take the benefit of Order 9 of the Civil Procedure Code in furtherance of your suit or the claim. Then comes the next consequence as to examination of the parties. Parties are to be examined. Witnesses are to be examined. Previously, when we started the practice, everything was, even examination in chief was in person taken. But by virtue of amendment, now there is a provision made, and whereby now examination in chief affidavits are filed. The cross-examination and further consequences. At this stage, friends, mind well that very intelligent person also, when he goes to witness box, likely to be confused. Even person like you and me, we are the professionals. Once you stand in the witness box, we may likely to be confused. And therefore, as a junior lawyer, to help your senior, take the examination or cross-examination of a person at your office and see whether he is correctly stating the things, whether he is well-versed in the facts. It is not that you are teaching something wrong to him. See that your client is telling the truth and the entire truth in the court, and he is not afraid or not confused because of that decorum of the court and that atmosphere in the court. Make him court-free, and he shall have the free access. And once this is done, then the stage comes as to admissions before the court. Especially you'll find the provisions in Order 10 relates to admissions. Admissions before the court. You have to vigilant. If the defendant has admitted in the written statement something about your claim, immediately you shall bring it to the notice of the court. That is, sir, the defendant has admitted, facts admitted, did not be proved as per the Indian Evidence Act. And therefore, this issue has to be raised for the consideration of the court. And then, if he has made any admission, then judgment in terms of admission can be given. Proceeding comes to an end. You need not wait for further 2 years. You need not wait for further examination of the parties before the court and arguments before the court. That ultimate judgment, Order 20 is different, and your judgment at this stage is different in respect of Order 10, Rule 1. This you have to do. And you should be vigilant how to read the arrangement of the section, arrangement of the orders, and especially this interplay and interaction between the provisions. If this is done, then comes the consequence in respect of Order 14 regarding issues. In civil suit, friends, framing of the issue is at most important. Sometimes you may ignore, you will say this is judge's job. Why? What I shall involve into this? No. Order 14 is very vital. Order 14 of the Civil Procedure Code decides the scope of the trial. What plaintiff has said, what defendant has said, and who has to prove what. Especially, friends, this topic, Order 14, framing of the issues in civil cases, civil trials, relates to provisions in Section 101 to Section 114 of the Indian Evidence Act of 1872. Numbers have been changed in the present Bharatiya Sakshya Adhiniyam 2023. So from section 101, 102, 103, and 104, who shall decide what? So not only for the purpose of framing of the issue, plain and written statement are to be taken into consideration, and therefrom it is your duty to bring to the notice of the honorable judge as to the burden is on whose shoulders. And that burden, we know, factum probans and onus probendi in the Evidence Act. What is to be proved is factum probans. And who shall prove his onus probendi? That onus probendi is to be found in Order 14 of the Civil Procedure Code as to issues. You should know not only plain and written statement, also read the relevant provisions in the Indian Evidence Act. See that the first section says, he who desires the court to give judgment has to prove. And therefore, based on the pleadings of the parties and the mutual pleadings of the parties, you should read the provisions in section 12104, section 101, 102, 103, and 104 of the old act, and further particular provisions in this behalf. That decides how actually civil trial will take place with the help of the Indian Evidence Act. That provides for issues, etc. Thereafter, the consequence comes in respect of the hearing takes place, the cross-examination takes place, witnesses are called for. In addition to this, stage comes of arguments. Friends, my senior has inculcated in me, which I am doing with my own colleagues at present also. Whenever we have got any case, my senior, he used to teach me 48 years back, 50 years back, and which now I am sharing with my colleagues today. That whenever a case comes in your hand, whenever a client comes you should know what is the present case law on this, what is the development of law on this. So you should not read the judgments and the law points when your case comes for hearing. Then you have to read and update yourself. But you have to start updating yourself in the beginning only. And friend, this starts in the beginning. When case comes to you, when you start drafting up the plain, at that time only you should know, and at the back of your mind, there should be such various judgments and pronouncements of the superior and constitutional courts in your mind. What is the law on the point? So that you did not plead the law. Order 6 specifically says, plead the facts and not the law. Even though you did not plead the law, even though you did not cite the judgments of the courts in your pleadings, nevertheless, what the court has said so, what the court has held so, and why, that will help you, and that will be at your back of mind. Your mind will be always working on this, and then start drafting. Your language will be yours, but the ideas and thoughts will be expressed in the judgments of the courts. That will help to draft your pleadings and nicely to draft your pleadings. First, this is done. Your brief is ready. Your brief is ready. Plaintiff file, all stages they have occurred. Witnesses have been examined, and then you come for hearing. Once you come for hearing and you start your hearing, then the arguments before the court, what happens? When you start arguments before the court, friends, then this is said to be opening of the case. It is not that you start as you wish. You must have that chronological aspect in case of opening up a case for arguments. You cannot simply take away any point at any time. From the beginning, from the plaint, you have to start. And then the evidence recorded, then the provisions of the Indian Evidence Act, and then the case law of the High Court or of the Supreme Court, if any, and then you have to make out your case. And therefore, well, in case of an argument before the court, you have to prepare thoroughly for this issue. Nowadays, the notes of argument, that is called as a written argument, is also allowed to be filed before the court, of course, in a very cozy manner, or in respect of a proper wording thereof. This provides in respect of the civil trial before the courts. In respect of this, I will have a few words with you. Abruptly, sometimes civil trial comes to an end. I will give you a few illustrations. There are around 14 illustrations today I have enlisted while I was reading for have the dialogue with you. First, Order 7, Rule 10. Order 7, Rule 10 provides that your plaint may be returned to you, to be presented to the proper court. Say, for instance, property situated, say, in Ahmednagar district, and you are filing a plaint for partition in the Pune district. Section 20 CPC says that where plaintiff resides or where defendant resides, that is different. But in respect of suits regarding immovable property, section 16, 17, and 18, they will regulate the scope, and therefore suit to be instituted within the jurisdiction of the court where the property is situated. Lex situs principle will be applicable in case of institution of such suits, and therefore suits might be necessarily instituted where the property is situated, and therefore such a plaint will be returned to you under Order 7, Rule 10. So here, whatever judgment is delivered is different thing. But when such small thing happens, that points out to your negligence. This is disrepute to an advocate. If plaint is rejected or plaint is returned on a meritorious ground, this is okay. But when plaint is returned on under Order 7, Rule 10, then this is the advocate's defect. This is advocate's negligence. And when there is advocate's negligence, client will naturally blame you for such a lapse on our part. And therefore, see that your plaint or your suit is not hit by Order 7, Rule 10. Otherwise, that will be sent to be presented before the proper court. Second is Order 7, Rule 11. This you will find almost in every civil suit. Nowadays, this Order 7, Rule 11 applications are filed. But they are very, very effective. Order 7, Rule 11, 6 grounds. As you will know, will not indulge into all details, but especially as to it is barred by law, there is no cause of action, it is not properly valued, copies are not given. These 6 grounds are stated. But friends, I will say that Order 7, Rule 11 comes into operation when, while drafting your plaint, you are not taken this precaution. Supreme Court has time and again and very recently has held that while deciding application under Order 7, Rule 11 will not take into consideration the WS and other material. What is to be taken into consideration? Only the plaint and plaint only. Means your own thing destroys your own plaint. And therefore, while drafting of the plaint, you have to take precaution that yes, I'm drafting in such a manner that provisions in Order 7, Rule 11 will not hit my case. That is how you have to skillfully draft. Like 710, what you have to take into consideration? Proper forum, proper place of the institution. Likewise, you have to see in this case that your plaint is so drafted that it will not be hit by Order 7, Rule 11. These are the 2 stages whereby the proceedings comes to an end before that particular case. Thirdly, the proceeding come to an end, Order 9, Rule 2, as just now we have discussed. Of the 14 terminations, third is Order 9, Rule 2. If you have failed to pay and deposit the costs for the service of the summons, then summons is not sent, and as summons is not sent, your suit is liable to be dismissed under Order 9, Rule 2. This is the third instance. Failure is again on fourth instance. That plaint is presented, suit is registered, summons is sent, but it came back, and there is reissuance of the summons just now we have discussed. Then Order 9, Rule 5 comes into operation. Order 9, Rule 5 comes into operation when you are not deposited, you are not again taken precautions to serve the summons or reissuance of the summons, or you are not deposited on the presented proper number of copies as per the number of the defendants. Then under Rule 5, Order 9, your suit is liable to be dismissed. This is the fourth instance. Fifth instance, whereby proceeding in the court abruptly comes to an end, is in respect of the provisions in Order 9, Rule 3 thereof. As per Order 9, Rule 3 thereof, whenever the date is provided in the summons for appearance of the parties, and especially on that date, irrespective of the service of the summons, no one appears, including the plaintiff, then the suit is liable to be dismissed under Rule 3 thereof. These are the first 5 instances. Then comes the fourth instance. Fourth instance is as per Order 10, Rule 4 into bracket 2. On the date mentioned, neither party appears before the court at the time of hearing. Irrespective of, the court has ordered for the parties to appear and to answer the claim of the plaintiff. neither party appears, then suit is liable to be dismissed. Then, just now we discussed under Order Rule 1, Order 10 Rule 1, if the plaint has been submitted, suit has been registered, and the defendant admits your claim. On admission, fact admitted need not be proved, then suit, in that case, judgment will be pronounced and there will be no further stages. At this early stage itself, the suit will be concluded and judgment will be pronounced by the court. Then comes the next consequence. As per Order 11, Rule 21, if there is any discovery, any inspection, or in respect of these orders have been passed by the court and the party is not cooperating, then as per provisions in Order 11, Rule 21, there can be order passed as to non-compliance. If it is plaintiff, suit is dismissed. If it is defendant, then there is striking of the defense of the defendant under Order 11, Rule 21. Stage comes to an end. Next stage is under Order 12, Rule 6. Again, that is judgment on admission provided. Again, Order 15, Rule 1. Parties are not at issue if on institution of a suit, plaint is presented, suit is registered, defendant appears, and his written statement is provided. And when court goes into the documents, then find that they are not at issue. Then the suit of the plaintiff is liable to be dismissed. And then comes the stage as to Order 15, Rule 4. And this is a stage when, in respect of recording of the evidence, hearing before the court, the party remains absent, or there is a failure on the part of the party to adduce the evidence. Then the court may proceed and the proceeding may be terminated into either judgment or dismissal of the suit. Then comes Order 17, Rule 2. Party's failure to attend the hearing. Usually you will find this, that there is hearing and party or advocate applies for adjournment. If it is adjourned, okay. If not adjourned, then further consequences, either ex parte will proceed or either dismissal of the suit will be provided. And especially Order 20, the last provision, and that is in respect of Rule 1. Once your case is heard by the judge, there are three consequences stated. Either judge shall provide for the judgment at once open court, or within 30 days from the hearing, or at the most it can be in respect of 60 days. In addition to these, friends, we should know one more aspect. And this especially is with reference to Order 6, Order 7, and Order 8. This you should know by heart. These provisions you should know by heart. If you are a plaintiff, you must know Order 6 and Order 7 thoroughly. If you are a defendant, you should know all these provisions thoroughly, because how to draft your return statement, Order 6 plus Order 8, and how to show the deficiencies in the plaint, you have to relate yourself to Order 7 of the Civil Procedure Code. In this connection, especially while drafting of the proceedings before the court, all the three orders should be kept in mind. Friends, that is how this entire procedure in civil procedure is to be seen. However, sometimes this is not sufficient, and there are incidental proceedings taking place. So, as we say that we are on the highway, and sometimes there is bypass, service road. Likewise, there are bypass and service roads. From the main proceeding, from the highway, you have to step down and join the bypass road and again come to the main road. Likewise, there are such proceedings provided, especially in Order 38, 39, and 40, interim proceedings. As to attachment before judgment, arrest before judgment, then Order 39 as to interim injunctions or interim reliefs, and Order 40 as to receivers, that we have to see. Sometimes, in respect of Order 6, Rule 17 and 18, amendment of pleadings. Sometimes, at such a place, you may be required to file amendment applications as to pleadings. Plaintiff as well as defendant can file this. But before drafting it, if you want to amend your plaint, or if you want to amend your return statement, or you want to oppose the amendment in the plaint or amendment in the written statement, then simply writing the objection will not be sufficient. You should know what is the present legal position on the point, what the court they provide for, in what cases such amendment will be allowed by the court, and therefore such amendment when will be allowed, that you have to take into consideration, and accordingly reading the judgments of the constitutional courts, you have to provide for writing up the applications or objections to the same. Especially, no new cause of action should be introduced is one of the point, and secondly, the parties shall not be displaced as to their defenses is another point, major points as to this. Especially, in addition to this, what you should remember is section 10, 11, and 12 as to stay of suits, as to doctrine of res judicata. These various provisions you should also keep in mind, because if you are filing a suit, instituting a suit, and presenting a plaint, then you should know beforehand whether my suit will be hit by res judicata. If it is hit by res judicata, then what will happen? Ignorance of the lawyer will come out of it, and so avoid it. Especially in respect of Order 8, Rule 6, and especially in respect of Rule 6A and afterwards, set off and counterclaim to be taken into consideration. Friends, many times, because of the simple lapse on the part of, or ignorance on the part of the advocates, there are serious drawbacks caused to the clients. If you are defendant, and say for instance, you have got a cause of action against the plaintiff in the same suit, then filing up the separate suit will be barred, and you have to file a counterclaim. This is a counter suit, in fact. And if you are not filing this counterclaim, or if you are not raising this counter suit in the present suit of the plaintiff, then your client's remedy will be barred. And therefore, you have to see, whenever any summons comes to you, and client comes with a summons and says, sir, that in respect of this, such a suit has been instituted against me, then in your mind, first Order 8, Rule 6, 6A, B, C, etc. shall come into mind. Whether there is a case of set off, and where there can be the provisions in respect of counterclaim to be instituted or not is to be seen by you. If it is not done, then at a later stage, your client will suffer because of your negligence. Friend, this is how within 1 hour's time, I have to correlate different provisions of the Code of Civil Procedure. With these, friends, I conclude, and I thank the organizers. Thank you very much.
Thank you so much, sir. It was really an honor, and it was a very insightful session for all of us. Sir, if you may kindly permit, we have a set of questions in our question and answer. May we proceed with that, sir?
Yes.
Okay. Just a minute. Yes. So the first question is, so there's a request, sir, to explain it in Marathi why CPC is called code and not act, sir.
In Marathi.
Yes, sir.
मित्रांनो, कायदे जेव्हा आपण करतो तेव्हा कायदे दोन प्रकारचे असतात. एक तर ते कायदे मंडळाने दिलेले असतात, किंवा अशा प्रकारचे कायदे हे आपल्या वेगवेगळ्या रूढी प्रथा किंवा कोर्टाचे न्याय निवाडे याच्यातून निर्माण झालेले असतात. त्याला स्टॅट्युटरी लॉ किंवा कस्टमरी लॉ असं आपण म्हणतो. हे जे स्टॅट्युटरी लॉ असतात ते 3 प्रकारचे असतात. जेव्हा ते एखाद्या राईट्स अँड ड्युटी संबंधाने असतात तेव्हा त्याला आपण सबस्टॅन्टिव्ह लॉ असं म्हणतो, आणि या सबस्टॅन्टिव्ह लॉच्या एन्फोर्समेंटसाठी कोर्टामध्ये वापरतो तेव्हा त्याला आपण प्रोसिजर लॉ असं म्हणतो. जेव्हा कोणताही कायदा एका विषयापुरता असतो, कॉन्ट्रॅक्ट ऍक्ट, तर त्याला आपण ऍक्ट असं म्हणतो. तिथे एक्झॉस्टिव्ह ट्रीटमेंट नसते. पण पार्टनरशिप इज ऑल्सो अ कॉन्ट्रॅक्ट, सेल ऑफ गुड्स इज ऑल्सो अ कॉन्ट्रॅक्ट, LLP इज ऑल्सो अ कॉन्ट्रॅक्ट. आणि जर का आपण इंडियन कॉन्ट्रॅक्ट ऍक्ट, पार्टनरशिप ऍक्ट, सेल ऑफ गुड्स ऍक्ट, LLP सगळे एकत्र आणले आणि एकच पुस्तक केलं असतं, मग काय झालं असतं, त्या विषयाचे सगळे कायदे आपण एकत्र आणले असते आणि आपण त्याला काय म्हणालो असतो, कोड. म्हणजे जेव्हा एखाद्या विषयासाठी दुसरं कोणतंच पुस्तक फॉलो करायची गरज पडत नाही तेव्हा त्याला म्हणायचं कोड. वेन इट इज डीलिंग विथ एक्झॉस्टिव्हली, दॅट इज कॉल्ड ॲज अ कोड. म्हणजे आपला आजचा जो विषय होता, संदर्भाचा विषय, त्या विषयामध्ये सिव्हिल कोर्टाची सगळी प्रोसिजर सांगितली, आणि म्हणून आपल्याला त्या विषयाला कोड असं म्हणायचं, ऍक्ट असं म्हणायचं नाही. आणि जर का उद्या आपल्याला इंडियन कॉन्ट्रॅक्ट कोड पाहिजे असेल तर त्याविषयीचे सगळे कायदे एकत्र घातले की तो कोड होईल. एक्झॉस्टिव्ह ट्रीटमेंट ऑफ लॉ इन वन सब्जेक्ट इज कॉल्ड ॲज कोड.
Thank you, sir. The next question, sir. Sir, they've asked to please give an example of suit valuation and how it is calculated?
For this purpose, for suit valuation, the Suits Valuation Act is to be taken into consideration. And based on the Suits Valuation Act and the rules stated therein, we have to evaluate the suit. And sometimes also, if it is monetary consideration, if it is for declaration and the reliefs under specific relief act, then there is a specific value or stamp is provided for, or valuation is provided for.
Okay, sir. Sir, the next question. May we kindly know the difference between res judicata and the doctrine of estoppel with an example?
See, these are two different aspects. One is from Civil Procedure Code, other is from the Indian Evidence Act. However, estoppel includes res judicata. Every res judicata is an estoppel, but every estoppel is not a res judicata. Simply, res means things, judicata means adjudicated. Res judicata means things adjudicated. And things adjudicated means that court is not the place of luxury or for wishful litigation. Once anything within the meaning of Article Section 11 of the Civil Procedure Code is finally and conclusively decided by the court, then again on that issue, there can be no other suit to be filed. एकदा जर का तुमच्या दरम्यानचे हे सगळे खटले ते सगळे इश्यू कोर्टाने कन्क्लुसिव्हली डिसाइड केले, गो इन द अपील or further provisions, but for this purpose there shall be no fresh suit to be instituted. This is res judicata. While estoppel, as stated in section 115 of the Old Evidence Act, is that it closes and setteth the mouth of the person to say contrary to his earlier act. He is stopped, he is prevented from doing something. And here also there is estoppel by deed and there is estoppel by record. आपल्या एव्हिडन्स ऍक्ट मध्ये, जुने एव्हिडन्स ऍक्ट मध्ये 115 सेक्शन नवीन बदललाय. त्या 115 सेक्शन मध्ये इस्टॉपेल बाय रेकॉर्ड आणि इस्टॉपेल बाय डीड असे दोन कॉन्सेप्ट डेव्हलप होतात. इस्टॉपेल बाय डीड म्हणजे काय? आम्ही लिहून दिलेलं डॉक्युमेंट. मी काल लिहून दिलेल्या डॉक्युमेंटची आज बोलायचं नाही. इस्टॉप, दिस इज इस्टॉपेल. आणि एकदा जर का रेकॉर्ड असेल, इस्टॉपेल बाय रेकॉर्ड म्हणजे जजमेंट ऑफ द कोर्ट. Once on the issue, court has pronounced the judgment, then I am stopped. This is the difference between estoppel and res judicata. Again, I will say in one sentence, res judicata is one branch of estoppel, but estoppel itself is exhaustive branch.